Okay, so now I have in front of me here the Disney's motion to dismiss, which was filed May 16, 2023. This was filed in the state court. So this is a motion to dismiss the board's lawsuit that they filed in state court against Disney. And so again, I've gone through and highlighted the main points here, but the first thing they're saying is that the court should dismiss plaintiff's amended complaint as moot, meaning the it doesn't have any more issues that need to be resolved. And then they're saying in the alternative, so if we don't dismiss the case for being moot, the court should stay the case under the priority principle, which basically means, hey, we filed first, which was in federal court, and our case encompasses all these issues already. And so since we were first, that court gets it. And then here are all the citations. And I'm going to read through some of this introduction here, and then I'll read some of the legal arguments. And then I have some comments on some things that I'm thinking might be happening in the background or that they might be setting up for. So just over a year ago, Disney expressed a political view that Governor DeSantis did not like, and we've gone over that with Don't Say Gay law. In response, the governor unleashed a campaign of retaliation, weaponizing the power of the government to punish Disney for its protected speech. Faced with a newly hostile state administration, Disney aimed to protect its planned investments in Central California, including thousands of new jobs and billions of dollars in capital over the next decade. They were going to spend $17 billion and bring 55,000 jobs to Florida was the plan. So they protected their investments in Central Florida by executing 2 development contracts with the local government body. And I'm going to come back to that later. But they say here, public notice appeared twice in a prominent Orlando newspaper, and there were 2 public hearings on the subject. Over no objection, the contracts were executed in early February. And last time we talked about in the district's lawsuit here in the state court, Florida State Court, the first reason they gave that Disney's contracts that they entered into with the board that were just referenced here, the first reason that the board said the contracts were void is for failure to follow notice requirements, specifically failing to mail notice prior to the first hearing to all affected property owners. And so I thought when I was first reading this that maybe Disney would mention that, and we did mail it, even though it wasn't in their complaint, but they didn't mention mailing, so I think maybe they didn't mail it for real. And yeah, so I think that's an interesting point there. A key component of the governor's retaliation campaign was to replace the elected board of Disney's local government entity with a hostile board, handpicked by the governor. And this is another thing that I talked about in the last time, in the last episode. We talked about how Governor DeSantis is saying we need to level the playing field so that Disney's has the same playing field as every other business. And my question was, well, do any of these other special districts that have a governor-appointed board, like now the Reedy Creek district has? Because if they don't, then it's not really equal footing. Is very different. But anyway, so Disney kind of touches on that here. They say none of the nearly 2,000 other special government districts in Florida underwent any similar state-mandated revision to its governance structure. So they're saying we're singled out here. And then they just kind of go on to tell the story we've already told twice now, which is that the board said that they were going to be voiding the contracts. And then they touch on here that, so shortly after how Governor DeSantis said that he was going to take issue with that through legislature. So shortly thereafter, the governor followed through on his additional threat to take action against the contracts at the state level. 4 days after the board filed this case here in state court, the governor signed a legislation he had previewed, effectively voiding the contracts as a matter of state law by prohibiting the board from complying with the terms of the contracts. And here's the language from Senate Bill 1604. It says an independent special district is precluded from complying with the terms of any development agreement which is executed within 3 months of a law modifying the manner of selecting members of the governing body. And that's what happened. Is it used to be 1 acre vote. You get 1 vote per acre owned, and that was switched from vote to appointment by the governor. So, I mean, obviously they had some mechanism to make sure that the contracts can't be enforced, and this was it. The contracts were signed February 8th, 2023, and obviously you got February, March, April, so less than 2 months later, April 5, 2023 is when Senate Bill 1604 is passed. So, I mean, obviously that's going to be within 3 months. So this law is designed to prohibit the enforcement of those contracts, so it's obviously going to fit in their requirements. But that's what the law actually says. That's how DeSantis was able to legislate around the contracts. So now let's go back to what Disney was saying in their motion. That legislation renders plaintiff's complaint moot because it makes any order this court could issue in either party's favor legally irrelevant. If the court rejects the board's claims on their merits and agrees with Disney that the contracts complied with any procedural and substantive for some reason I have a hard time saying that word, requirements of state law, the board would still be prohibited from complying with them under the new statute. So if I'm saying that, it's like, hey, court, if you say the contracts are valid, then we don't get anywhere because the law says they can't be enforced anyway. For the same reason, even if the court found merit in the board's objection to the contracts, any order to that effect would be pointless because the contracts would already be void under the new state law. In short, any declaration about the contract's enforceability, voidness, or validity either way would be an advisory opinion with no real-world consequence. Trial courts in Florida are forbidden from issuing advisory opinions, and this case should be dismissed. So the way that I'm kind of taking this is Disney is saying, for the sake of the state court action, we have that law, which was House Bill 1604, which says that you can't enforce this contract anyway. So we're just going to say that law is valid. We're not going to fight that law. And so since that law says that these contracts are invalid, we don't need also a court to determine that they're invalid. We accept that this law was instituted, contracts are invalid. Okay, that's fine. So there's no need for a court to issue an order on that. And it's a really good point, because what Disney is doing here is they're trying to get this case out of state court and put it all in federal court. And in federal court, what they're saying is, okay, yeah, even though we're not saying that 1604 is invalid for any reasons specific to 1604, what we're saying is 1604 was implemented unconstitutionally in violation of as a way of attacking us for speaking out against the Don't Say Gay law. And that's the reason why it was enacted. So even though it's a valid law right now, we're asking the federal court to invalidate it because it was implemented for retaliation against Disney, specifically for the First Amendment issues. So in this way, this is how Disney is trying to keep all of the case in Florida federal court where they filed. And interestingly enough, I read on the news that DeSantis has filed a motion for the federal court judge to recuse himself, saying that he's biased. And I'm going to talk a little bit about that later, but let me go down and just to touch on some more of these legal arguments here, just so we can cover all the details. The legal standard here is basically that it is the function of a judicial tribunal to decide actual controversies by a judgment which can be carried into effect, and not to give opinions on moot questions or to declare principles or rules of law which cannot affect the matter an issue. So again, it's just basically saying, hey, state court, however you come out on this, it doesn't matter, because we are already agreeing that the contracts are not enforceable based on a later enacted law. And then their alternative standard, which is basically saying, since we filed first in federal court, and the federal court already encompasses all issues related to these contracts, that court should get the first bite at the apple, or the only bite at the apple, I guess. And they say here that it is an abuse of discretion. So if the judge decides it would be bad decision to refuse to stay a subsequently filed state court action in favor of a previously filed federal action, which involves the same parties and the same or substantially similar issues. And in the argument, again, for the motion to dismiss for mootness, they say here the courts reserve their powers for cases involving actual controversies. Florida courts will dismiss a case if the issue raised have become moot, and an issue is moot when the controversy has been so fully resolved that a judicial determination can have no actual effect. And the important thing is that the state court case is limited only to the issues of, are the contracts enforceable? And effectively Disney is saying no, not necessarily because of what the board is saying, but because there's a law that says they're unenforceable. And so, yeah, I mean, I've already said that. And that's what, yeah, so they say, Disney says there is no order this court can issue that will affect the result, which is that this action is by a state board raising questions of validity of the contracts that are already void and unenforceable by unequivocal legislative. They say fiat. I don't know if I'd use that word because it's kind of in my mind a little bit of a has a negative connotation. I would have just said by legislative, act. So no matter how this court answers them, the board will not comply with the contracts because it legally cannot. Senate Bill 1604, I said House Bill, I guess it's Senate Bill, provides without qualification that the board is precluded from complying with the terms of the contract. And then notably here, they do note that there are some situations when a case can still go forward, even though there are issues with the question being moot. And that is the first one where questions raised are of great public importance. The second one is where the questions raised are likely to recur. Or the third one is where there are collateral legal consequences that affect the rights of a party that flow from the issue to be determined. And of course, they go on to say that none of these exceptions apply here. And I'm not going to get into that now because I want to see if the board is going to try and keep their case here in state court. And I'm assuming that they will. And I'm assuming it's going to be based on one of these exceptions, probably number one. And maybe I'll get into that too, because I am going to come back to this very first issue that I said I would come back to here in the introduction, because I think what Disney's doing here when they say that they're protecting their planned investments, I think they're giving us a little bit of a foreshadowing of what their theme and their argument is going to be. They're going to come in and say, because what I think, let me back up a little more. What I think DeSantis is going to do is they're going to say, hey, look at Disney coming in and trying to shove these last minute 11th hour contracts down Florida's throat is the exact type of thing that we need to institute this board for in the first place. That's why they need oversight. They're doing stuff like this. This isn't the only time. It's been going on forever, since 1967. They've pulled fast ones on us. This was supposed to be a residential community. That's what Epcot was supposed to be. That's what they told us. Now it's not. Never happened. It's like they're always just pulling the wool over our eyes. That's I think the way that Florida will pitch it, and what Disney will say is like, well, we have a duty to our shareholders to protect our investments, to have a good business. And that's all we're doing with the contracts is protecting our investments. Governor DeSantis himself said that that's what corporations should be doing. And I'm going to play a clip of that. Okay, so I pulled up this video here. This is not specifically about Disney. This is a speech about ESGs, or I guess ESGs. It's environmental and social governance of corporations. So it's woke politics. On the podium, of course, it says here, government of laws, not woke politics. And this was from a speech on February 13, 2023, just a few days after the passing of House Bill 9B. And that's the one that reconstituted the district, renaming it the Central Florida Tourism Oversight Board, and allowing Governor DeSantis to appoint his own board. But that's where we are in the chronology. This is his talk about woke politics in corporations, and I think it's important because it shows his line of thinking in doing all of these types of things.
The subject of today is tackling this issue of ESG. Now, they created this. These things just happen. I don't know where this stuff comes from, but these elites grab it and they really want to impose it on the rest of us. So it's called environment social governance, but basically I think what it's devolved into is a mechanism to inject political ideology into investment decisions, corporate governance, and really just the everyday economy. That is not
politics.
Ultimately something that is going to work out well for us here in Florida or in the United States of America. There's not a real groundswell for this amongst the average citizen. It also...
I just want to add, when he says it won't work out well, that's something that Disney said that he told Bob Chapek when they first spoke on the phone about Disney wanting to get involved and say something about the Parental Rights and Education Act.
Violates the fiduciary duty that executives have to the shareholders of the publicly traded companies. You think about it, your pension money, your retirement money is likely invested in some of these funds, and those funds should be done to try to produce the best result for you using the available investment options. Well, what ESG says is, no, we're not going to do, even if it would do a better return, we're not going to allow you to invest in certain areas. You're not allowed to invest in oil and gas. You're not allowed to invest in disfavored areas. So they're constricting the ability of people to invest your money, and obviously that means you're going to not do as well as you otherwise could have.
So in other words, these companies are going to be pursuing these woke political agendas rather than pursuing the best returns for their shareholders.
So that is using your economic power to advance a political agenda. Now, this is something that I think is very serious because I think the policies are bad. I think having a politicized economy is not the way that you want to go. But it raises the idea of who governs our society. Our Constitution says we, the people, govern through elections and different houses of the legislature, executive, and you can kind of arrive at policy. People can evaluate that. They can choose other people in future elections. Well, what ESG does, and when you have major asset managers and these international folks and folks in these big Wall Street banks, they just want to do an end run around that. They don't want to have to worry about winning elections. In fact, a lot of the policies they pursue could never win favor with the American public. I mean, abolish ICE, saying that you should have an open border and that it's somehow wrong to be involved in immigration enforcement, that would never fly with the public. But that's what they're doing. And so this is this is a distortion of a government of, by, and for the people. They are not accountable to you. They are not accountable to us. And I think ultimately it does represent a threat, not just to a smooth and prosperous economy, smooth functioning, prosperous economy, but also our very freedom itself.
So I think these are going to be the competing themes. Disney's saying we're just trying to be a responsible corporation, doing things that are the best for our, I'll say, constituents / shareholders. DeSantis is going to be saying we're doing what our constituents want and what's best for the people of Florida by making sure that Disney can't be its own government because of things like this. So anyway, I think that's some foreshadowing, but I think this is a great move by Disney. When I read it, I was just like, oh man, these guys are good. But I also think that DeSantis's attorneys have been very good. And last time when in the news you saw that these contracts, Disney, Disney gets the last laugh, or things of that nature. But then DeSantis overcomes that because, I mean, we're dealing with smart guys. They all happen to be guys. All the attorneys. Yeah. Anyway, we're dealing with smart attorneys, and I'm really interested to see how they're going to respond to this motion to dismiss. But when I read it, I think it's a good motion. I actually think Disney's right that if they're agreeing that the contracts are invalid by the law, then there's no point for the state court to also say, yeah, that's right, they are invalid. Unless those exceptions apply again, and I'll get those once I see how the board is going to respond, because I'm not doing that work. All right. Okay. So that covers the motion to dismiss, and I'll let you know when I see what happens next from here.